Good evening, everybody. Welcome to the 96th webinar of Child Conservation Foundation, associated with Seva Bharati. We have been trying to cover all the topics concerning with the children. Today, it's our international webinar. We have Veronica, Gabriel, Buchumi, LLM, LLB, and PhD from the Bayreuth University, Germany. She is a faculty of Salam School of Law in Tanzania, a postgraduate diploma in legal practices. Apart from that, she is a member of IFCO, International Foster Care Organization, a proud member of IFCO. The subject which we are going to talk today is the challenges associated with supporting foster care, specifically in developing countries. If we talk in our Indian context, JJ Act defines in section 44, there is little bit definition about the foster care, who is the foster care family, what is the definition of foster care. So basically, to provide a family outside the family is the major aspect or the major aim of the foster family. So to talk in detail, I will invite Veronica. It's over to you. Please speak on the subject. Please unmute and speak on the subject. The subject is challenges associated with supporting foster care families in developing countries. Over to you, Veronica. Veronica, can you listen me? Yeah.
Yeah, I can. I hope you can all hear me.
Yes, we are here. We can listen. Go ahead.
I want to share my PowerPoint.
Okay.
Yeah.
So you can go on share and directly you can share it from your screen.
Let me. I'm trying to. Just a minute. I'll get it.
Okay.
Can you already see it?
No. Yes, I think.
Let me put slide.
Yes, we can see it.
Yes, we can see.
Yeah.
Yes.
Unfortunately, I can't see you all. How do I do that? Can you help me?
That's a difficult task. You need to have two instruments to see that. So you will be only.
Okay.
Yeah, it's a difficult thing, but we can see you. So maybe if we have any issues, then we'll let you know.
All right, no problem. I thought I would also have an opportunity to see you all.
Yeah.
All right. In the first place, let me in a special way thank Vasundhara for her initiative to invite International Foster Care Organization to present in the series of webinars that you have been operating for a while now. And I am happy to be the first speaker from IFCO to join the webinars, and I am so excited to hear and exchange experience with you. So yeah, as I was introduced, I am currently working at the University of Dar es Salaam School of Law as a lecturer after completing my PhD last year. And I was doing my research on foster care for a period of 4 years back. And it has become one of the areas that I'm really interested to conduct my research and see how we can cause care reforms in our countries, like in most of our developing countries where foster care is either being started or is still a conceived idea that has not taken place. So yeah, and I thought today we would just have a discussion on supporting foster carers in developing countries. And I'll be drawing most of my examples from Tanzania, where I have done extensive research on foster care. I would also refer to some other countries like Ghana, Uganda, Kenya, where they are also trying to establish foster care as an alternative care for those children who are deprived of their family environment. And maybe just a short outline of my presentation. So I'll have a short introduction, like why talk of foster care. Then I'll also have a slide on developing countries and alternative care for children. Then I'll also look at foster care as an alternative care, just briefly, because I believe we all have an idea of what foster care is and its place in the continuum of care. And after that, I will briefly discuss the essentials of an ideal foster care system. Like when we talk of foster care system, what are we actually entailing? What should be the components that could make foster care a reality in our countries? And then I'll also have a slide on the inherent place of foster carers, where I believe that without foster carers, there cannot be a foster care system that is well functioning. And then after that, we'll talk on the importance of supporting foster carers. And after that, I'll now concentrate on discussing challenges affecting support for foster carers. And after that, I think it will be just an opportunity for us to share experiences on the area of support for foster carers from Indian perspective and from the Tanzanian perspective. So by way of introduction, I would say that children in need of alternative care are entitled to heightened level of protection because of the increased level of vulnerability that they face in that state. And I believe we all appreciate that without a family, a child becomes vulnerable and their development and welfare becomes in danger. And the need to protect children that are deprived of their family environment or those who are needing alternative care has been recognized and guaranteed under various international, regional, and national frameworks that aim at protecting children. So for instance, the Convention on the Rights of the Child and Article 20, it puts an obligation on the states to ensure that children without a family environment are provided with an alternative. The same, if I narrow down to what is happening in Africa, we have a specific Convention on the Rights of the Child, and it also recognizes the right to alternative care for children that are in need of alternative care. And actually, in different countries in East Africa, in West Africa, they have their laws on child protection have provisions that demand provision of alternative care to these children. And in the end, you find that the responsibility to care for these children is a responsibility not only to the state, but also of the entire community. So we as a whole have a responsibility to ensure that children who cannot remain in their families or whose parents cannot provide appropriate care are given an alternative to their family care. And an interesting thing when we talk of alternative care is to appreciate that there is no one size fits all care options. So though I am talking of foster care today, I'm not advocating for foster care as the only alternative care option or as the only best alternative care option, but it's just one among the other possible alternative care options that can be used to meet the different needs of children who come into the alternative care system. Now, when we talk of developing countries and alternative care, we find that in the first place, the factors that lead children to be deprived of their family environment, they might be the same across the world. Issues of child abuse, neglect, family breakdown, disorganization, poverty, drug addiction, all these could contribute to children being deprived in their family environment. And for Tanzania specifically, I would say most of the children come into alternative care system because of neglect or child abuse, and sometimes because of the family breakdown and disorganization of social groups that have been playing an important role in protecting children. But also HIV/AIDS has also been another contributing factor to children that are being deprived of their family environment, not only in Tanzania, but across other sub-Saharan African countries. And an interesting thing to note is that, for instance, if I talk now specifically Tanzania, most of the alternative care services, whether it's prevention services, whether it's provision of alternative care services, they are handled by non-government organizations. And the government, for instance, in Tanzania, it plays a major role of maybe supervising what NGOs are doing. And to substantiate what I'm saying, for instance, here in Tanzania now, we only have one children's home that is owned by the state, and all other children's homes that are there, they are owned by non-government organizations who actually play a bigger role in ensuring the protection of children who are in need of alternative care, but generally children who are in a vulnerable situation. And of course, as I'm mentioning, there is over-institutionalization of children in most of the countries around East Africa, West Africa, for instance. Ghana it's only recent that it's developing its foster care system. But over time, institutional care has been the key alternative care option in most of the developing countries. And for instance, in Tanzania, it is only like 2012, around 2012, 2013, that they introduced a program called Fit Family, where now there are initiatives being taken to ensure that not all children are put into institutional care, but they are taken by fit families, which in a way is similar to what we refer as foster care, but it is named as a fit family scheme here in Tanzania. And the interesting thing to note is that most of these developing countries, including Tanzania, the legal frameworks on child protection prioritize family-based alternative care options, but in practice, we hardly see family-based alternative care being a priority. It's rather, it only happens, for instance, with adoption in Tanzania, it only takes place at the pleasure of the adopters. So it's only when a person wants to adopt that you can see adoption of children taking place in Tanzania. Otherwise, every other child who needs alternative care will be placed in a children's home, because that's the only, not the only, but it's the most available means of alternative care option here in Tanzania. However, we can see, and I believe we can also appreciate with what is also going on in India, that most developing countries are now also trying to deinstitutionalize alternative care services and expand their options of alternative or family-based alternative care options. So that's generally an overview of what is happening in developing countries like Tanzania and other sub-Saharan countries in the area of alternative care. Now, when we talk of foster care as an alternative care, in the first place, it's a family-based alternative care option, which takes place in the domestic environment of the carer. So unlike institutional care, where children would be placed in a designated area, children who are placed with foster care, they will be living with their carers in their domestic homes, unlike institutional care. Now, I'm sorry, I didn't get your name, the one who was introduced, or who is moderating, as the moderator said, you know, foster care has...
I'm Dr. Chaube. Dr. Chaube.
Dr. Chaube. Okay, thanks. Yeah, so defining foster care is not an easy task, because different people, different countries have a different understanding of what foster care is. But at least one of the common agreement is that it's a family-based alternative care that takes place in a family environment And for instance, I would just point out a few definitions that I think can help us see how foster care has been defined. So for instance, the UN guidelines of 2009 define foster care as situations where children are placed by a competent authority for the purpose of alternative care in the domestic environment of a family other than the children's own family that has been selected, qualified, approved, and supervised for providing such care. So if you look at the definition given by the UN guidelines for alternative care of children, it talks of form of foster care, that which is prescribed by the state authorities. And if I narrow down to what we have in Tanzania, foster care or fosterage is defined in our Law of the Child Act as a temporary measure provided on voluntary basis by the family and the individual who is not related to a child to discharge care and protection to the child. So you can already see that foster care can be defined differently, but what is key is that it's an option, it's an alternative for those children who cannot be cared by their parents. And the care in most cases would be taking place in the domestic family of the carer. And with these different definitions, you find that foster care can be taking different forms. It can be short-term foster care or long-term foster care. It can be, sometimes there are other countries which have foster care for adoption, and then there could be kinship foster care, where foster care is being done by relatives of a child. It could also be non-kinship foster care, like what we have in Tanzania, or respite foster care to relieve maybe parents who are overwhelmed with their care responsibilities, or therapeutic care to provide special treatment to children who might be in need of such services, and sometimes emergency foster care. So it can take different forms. And for me, I feel like this is an advantage of foster care, because then countries can decide what they want as far as foster care is concerned, because there are no hard and fast rules as to how foster care should be So it's left upon the states to decide what works for them and what form of foster care would meet the needs of the children that come into the alternative care system. And another important thing that differentiates foster care from maybe adoption or some other kind of alternative care is that it doesn't sever the biological links of the child So the parental rights remain to the parents. The parents continue to be recognized as the parents of the child, and the relationship can be maintained, unlike closed adoption where the biological ties are usually severed once adoption is done. So this is also an added advantage because the child can also, depending on where the child is placed in foster care, they can still maintain cultural ties, identity ties with their biological family. Now, before we go to discuss on the importance of supporting foster carers and the challenges associated with that, I thought it would be nice to discuss on the essentials of an ideal foster care system. So though I am saying that there are no hard and fast rules of what foster care should be, but there are certain elements that I think and I feel like they are very essential for them to be there in order for foster care to at least effectively function. And one of the things that I consider essential is a robust and coordinated legal and policy framework. I believe we all know the importance of law in organizing our society. So if we have a clear legal and policy framework, it's from that where we can know what foster care means in our context and what kind of foster care we want to implement in our context. So if we have a clear legal and policy framework, it already paves or it already puts a good foundation for establishing a foster care system in a given country. But in addition to the effective legal and policy framework or sufficient legal and policy framework, we also need a competent and sufficient social service workforce. Like the social workforce should be adequate, it should be competent, aware of of its role when it comes to foster care. For instance, as I was doing my PhD research, one of the challenges that I discovered as far as foster care is concerned in Tanzania is that our social workforce had a limited knowledge or understanding of what foster care is. And in the end, we have ended up having foster care only for adoption. And they would just tell you, like, we cannot foster a child if the ultimate goal is not adoption. But, foster care has more potentials than just facilitating individuals who want to adopt. That's why a competent and sufficient social service workforce is very essential for an effective or an ideal foster care system. Another important aspect, and which will be of our concern today, is the pool of foster carers. Like, as I said in the beginning, without foster carers or without having foster families, we cannot have a foster care system in place. So states that are aspiring to develop a foster care system, they should be in a position to articulate mechanisms that they will adopt to ensure recruitment and retention of foster carers with whom children can be placed with once there is a need. And finally is the need to have support services for foster care placements in place. So this would mean that we need support services for children who are placed in care. We need support services for the social workforce that is in charge of supervising and overseeing all activities related to foster care system, whether they are government social work or social workers or their NGO social work. There should be supporting services to facilitate the activities, but also support services for the foster families who, as we will see shortly, they have they have vast responsibilities when it comes to foster care placements. So, and above all this, we also need a society that is ready to embrace the potentials of foster care when it comes to protection of our children. I hope I'm not taking too much time already. And then the other aspect, now, as I said, today we are concentrating mostly on supporting foster carers, is the inherent place of foster carers, which I have already briefly stated, that we cannot have foster care without foster carers. They have many responsibilities when it comes to caring for children that are being put in their care. They have to provide accommodation for them. They have to provide meals for them, their clothing, their education, and any other day-to-day needs that a child might be needing. And apart from these care responsibilities that they have towards children, foster carers also have to deal with new developing relationships, because once a child, in most cases, there will be a biological family, which somewhere, somehow, they will interact with foster carers, especially if the end goal of foster care is to reintegrate the child back to their family or reuniting them with their families. And they also have to deal with state authorities like social workers. So their responsibilities can be overwhelming depending on the relationships that develop in the course of fulfilling their foster care responsibilities. And it is out of this inherent place of foster carers and the responsibilities that they perform that the issue of supporting them becomes very essential. That without supporting them, without having a proper system to ensure that they can discharge their responsibilities, we will not be in a position to retain enough foster carers, because we'll be recruiting them and they will be quitting, or they will be retiring because of the unconducive or unfriendly environment that is in foster care. Now, the support for foster carers, when we talk of support, in the first place, it's very essential for recruiting and retaining foster carers. So in the campaigns that we might be doing to improve, to recruit foster carers, it's important to have a clear framework of what support foster carers get, because as we have said, they have to provide accommodation, they have to provide meals, they have to provide sometimes health or medical services to these children. And for instance, in Tanzania, there is nowhere in the legal framework where it is prescribed that a child in alternative care will be provided with, for instance, a health insurance, a health insurance cover. So at some point, it would be the responsibility of this foster carer to provide for the child. And so it's nice to have this awareness that foster carers have responsibilities that they might need support, and on their own, they might not be in a position to discharge all that is expected from them. And now, support for foster carers can take different forms, like monetary, like you give them allowances, which is done in most of the countries. For instance, in Africa, Ghana provides some kind of allowance. They even have a foster care fund. In South Africa, they also have a grant that they provide to foster carers. And in most developed countries, of course, an allowance is there for foster carers. Sometimes material support is given, but also there could be need for moral support, and sometimes even emotional support depending on the nature of the placement, because sometimes the children who come into care might be having complex issues that might need attention of psychological support, which might in one way or another affect foster carers. And support can also be formal or informal, depending on the circumstances and aims of the foster care system. And then another thing, now, when we talk of support for foster carers, this is one of the areas where in most countries it has been controversial, because the question has been, if foster carers have to be supported, what would then be the motive for foster carers? Would it be the support that they are promised to get once they have taken up a child, or would it be the desire to just provide a safe environment for the child? So in some countries, for instance, in Tanzania, if you look at our law on foster care, it is very silent on support or like providing allowance. There's no that guarantee that if you foster a child, you will be given an allowance. And maybe that has not become a big issue now, because in Tanzania so far, foster care is being used as a means to adoption. So in most cases, those who foster, they would be having the capacity to care for the child because they actually want to adopt the child. So far, we don't provide foster care grants or foster care allowances, because that has been the practice. And even the equivalent of foster care that we are implementing now, the Fit Family Scheme, there is no support for the families that take up children to provide for their care. So there is this controversy, like, should we really support foster families? Will we not preempt, or will we not affect the motive for which they come to foster children. So that's something that we can also share. Like I would be happy to hear like how India is doing it, like how do they support foster carers, and maybe in the end we'll have an opportunity to share some challenge that you have been facing as far as support for foster carers is concerned. So now if I now try to discuss the challenges for supporting foster carers. One of the things for like most of the developing countries or African countries, Tanzania included, is the question of cultural resistance and the influence of social norms. Because over time, the issue of caring for children who cannot be taken care by their biological parents, it has been a private affair. Like it has been an issue that has to be solved within the extended family. So over time, the government didn't have a big responsibility as far as children who cannot be cared for are concerned. Because if a child's parents dies, then the aunt or uncle somewhere will just sort out how the care of this child will be. And it's also not so common to see a person allowing their own children to be taken care of by a stranger, maybe so to say. So there is this tension, like a cultural tension on the acceptability of foster carers, because in the end they would be challenged. Like, you only want to foster because you get some benefits, because it's so uncommon to invite strangers in your family because it's believed that like every person has somebody in the extended family to care for them. So the influence of social norms becomes a challenge. I was recently speaking to one of the manager of an NGO in one of the regions in Tanzania where they operate this fit family scheme. And she was saying it was a challenge in the beginning to get fit families, because the neighbors would be looking at the individuals who have volunteered to be fit families, like, what are you doing? This is not something of our own. So in the end, even the community members will not give their required support to these potential foster carers or the fit families that we have now in Tanzania, because of the cultural resistance or the cultural situation or context that we have in most of the African countries, where kinship has been playing a major role in caring for children. But another challenge that emanates from supporting foster carers is the question of poverty at the national level and at the individual level. So like the state, for instance, if we talk of the government, does it have enough resources to provide, for instance, allowances to these individuals who are volunteering to take in children that are in need of alternative care? And the other way of looking at it is like, are families in developing countries able to take up a child and provide for them? Because sometimes we have families who cannot even care for their own children. So would it be possible for this person to invite or to open their doors to receive another child? So in the end, the question of supporting foster carers becomes tricky, because the government also doesn't want to put obligation on itself of providing for the necessary needs of the children who are being placed in foster care. And at some point, even the individuals themselves at the community level might not be in a position to provide the essential services to facilitate foster care placements. And in relation to the question of poverty is the issue of the difficult realities of the social protection in most developing countries, or the dynamics of social protection schemes. So for instance, when I was doing my PhD, I thought like, okay, maybe now, like, because now in Tanzania, our law does not provide for monetary support for foster carers. And when you ask the government officials in the social welfare department, they will tell you it's because we don't want to make children a business, and we don't want to make people come to foster because of the allowance they get. So I was like, maybe it could be possible to provide children who are going into foster care with some maybe material needs more. So for education, maybe they give them exercise books, they give them maybe national health, like they give him a health insurance cover, like they cover for their basic needs so that the foster care doesn't have to go into their pocket to provide for this child. But then you ask yourself, in a typical, for instance, Tanzanian family, most of the individuals don't even have insurance covers. So if you have children of your own and then you open a door because you have maybe an extra room and you're able to provide for food, and then the government brings in this child, a foster child, and they provide this child with a health insurance cover, they give them books. What about your own children? So this reality is that, you know, we have families where there is no guarantee. It's only the parent that has to shoulder every responsibility. And here you receive a child whose needs is then catered for by the government. How will you feel as a foster carer, and how will your own children feel when a child who came into their house is given all the necessaries from the government and they're not receiving anything simply because they're being cared for by their children? So these are difficult realities that face most of the developing countries when it comes to supporting foster carers. And in the end, it is left for those who are only able, like those who are economically well, to open up their doors to become foster carers. And this, in the end, reduces the pool from which foster carers can be recruited. And another challenge that I have seen when I try to assess different legal frameworks on developing countries, especially in East Africa and Ghana, where in West Africa, where I referred extensively in my work, was lack of comprehensive legal and institutional frameworks on supporting foster care. So as I said, for instance, in Tanzania, our foster care regulations, it doesn't have a comprehensive provisions on the need to support foster carers, even to provide them with necessary trainings and to help them cope with the new relationships that are being established. Our social welfare is also our social welfare department is also lacking in terms of, it has inadequate personnel, it has, its understanding on foster care itself is very narrow. So in the end, even when you talk of supporting foster carers, you don't have a good basis from the legal and institutional frameworks to enhance protection, to enhance support for foster carers. And related to that, I think I've already explained, is the issue of limited understanding of foster care and its potential by a large part of the community. So as I said, for instance, in Tanzania, foster carers are those who want to adopt a child. And, you know, that's how it's being understood. Like, you know, you only foster because it's a requirement by the law that before you adopt a child, you have to foster for six months. So with this limited understanding of foster care, the social welfare officers, for instance, they don't expect that if a person who wants to adopt would need support from the government to care for the child that they want to adopt. In fact, that would be a negative sign for you or for your assessment if you are suitable to adopt a child or not, if you will be expecting support from the state. And finally, I think it's related to the last but third point, inadequate and insufficient social workforce, because then supporting foster carers would need an adequate or sufficient social workforce that is able to, you know, to be close to the foster carers to figure out what their needs are. Because as I said, the support that foster carers need would be beyond monetary support. Sometimes they need emotional support. Sometimes they need to be assisted on how to care and meet the different needs of children who are coming into foster care placements. So generally, if you look, these are the common challenges that would be affecting the need to support foster carers in most of the developing countries, and specifically Tanzania, where I am based and where I have done extensive research on. And now, as I said, I would be delighted, or I am delighted to share experiences from the Indian perspective, like what has been the challenges that India has been facing when it comes to providing appropriate support to foster carers. And I would also be happy to hear from your experiences, like what measures has India taken to overcome the challenges that we will share towards improving foster care system in the country.
Thank you, Veronica. More or less the challenges are the same: awareness, data, training, all the aspects. We'll be covering in the end of the session. We'll be sharing our experiences. Since our second speaker has already joined, and he has certain time constraint. He has to go somewhere. So we'll just listen
Alright.
our second speaker, and then we'll continue the session with you. Everybody will share their experiences specific in the Indian context. So thank you very much, Veronica. Don't go away. We'll just
Thank
call
you.
you after this second session. So
Yeah.
पॉक्सो एक्ट 2020 के नियम 9 में कंपनसेशन के बारे में लिखा गया है. The special court may in appropriate cases on its own or on an application filed by or on behalf of the child pass an order for interim compensation to meet the needs of the child for relief or rehabilitation at any stage after registration for the first information report. वास्तव में कंपनसेशन क्या होता है, विक्टिम कंपनसेशन किस प्रकार दिया जाता है, मुझे लगता है निपुण सक्सेना से ज्यादा अच्छा इस बारे में कोई नहीं बता सकता है. निपुण सक्सेना is a practitioner advocate in Supreme Court and he has appeared as a civil side in many cases from CBI and NIA also. निपुण, स्वागत है आपका. निपुण सक्सेना वर्सेस यूनियन ऑफ इंडिया, इस जजमेंट के बारे में हम आपसे बात करेंगे. ओवर टू यू निपुण. विक्टिम कंपनसेशन क्या होता है, किस प्रकार से हासिल किया जाता है, और स्पेसिफिकली हम बाल कल्याण समितियों की जब बात करें तो उनके क्या रोल होते हैं, इस पे बात करेंगे. हमारे अध्यक्ष जी भी जुड़ गए हैं. भाई साहब, स्वागत है आपका.
जी धन्यवाद
जी,
स्वागत है निपुण जी आपका.
जी,
thank you so much, Dr. Sharma, Dr. Chaube, for a wonderful introduction, and also I have had the distinct pleasure of listening to Veronica, and I think some of the ideas and the notions that have been highlighted and underscored are something that we resonate to in the Indian context. So for today's discourse, what I've tried to do is that I will keep it bilingual. मैं हिंदी में भी थोड़ा बात करूंगा, मैं अंग्रेजी में भी वार्तालाप करूंगा, जिससे विक्टिम कॉम्पनसेशन स्कीम जो है उसके बारे में एक जो प्रोविजन कहता है वर्सेस जो जजमेंट में लिखा गया और जो डायरेक्शंस पास हुए हैं उनका कैसा इंटरप्ले होता है. So what I will be doing is I'll be discussing the context of the statutory scheme that talks about victim compensation as mandated under the POCSO Act, which is the Protection of Children of Sexual Offences Act of 2012. And then I'm also going to look at the judgments that have examined the scope and the effect of the victim compensation scheme and how exactly it pans out. So briefly dealing with the first such instance of victim compensation was a case which was called Chairman of Railway Board versus Chandrama Das. चंद्रमा दास के केस में माननीय सर्वोच्च न्यायालय ने पहली बार मुआवजे की बात की थी. विक्टिम कॉम्पनसेशन स्कीम में चंद्रमा दास में माननीय सर्वोच्च न्यायालय ने कहा था कि अनुच्छेद 32 के अंतर्गत एक पब्लिक लॉ रेमेडी है जिसके अंतर्गत हम कॉम्पनसेशन दे सकते हैं. Which is to say that the Honorable Supreme Court of India and the Chandrama Das case had specifically stated that irrespective of whether there is a statutory scheme in force or not, nothing precludes us from passing directions insofar as compensation of victim is concerned, and that public law remedy is available to us under Article 32 of the Constitution, which talks of writ remedies. Right? अब जो specific context है compensation का वो तब तक नहीं बना था. तब एक बहुत ही इंटरेस्टिंग केस आया था सर्वोच्च न्यायालय के सामने. ये 1995 का केस था जिसका नाम था दिल्ली डेवलपमेंट वर्किंग वुमेन्स फोरम वर्सेस यूनियन ऑफ इंडिया. There was another case in the year 1995 which followed the previous case of the Supreme Court, which was called the DDW versus Union of India, which is the Delhi Development Working Women's Forum. उस केस में ये हुआ था कि एक रेलवे कंपार्टमेंट के अंदर कम से कम 14 से 15 महिला सफाई कर्मचारी थीं जिनके साथ बलात्कार किया गया था. और चूंकि नेक्स्ट कंपार्टमेंट ही आर्म्ड ऑफिसर्स का था, इसलिए आर्म्ड ऑफिसर्स ने इमीडिएटली उनको अरेस्ट करके डिटेन कर दिया था. जो लोग थे वो कमजोर, इकोनॉमिकली कमजोर वर्ग से आते थे, इसीलिए उनसे कॉम्पनसेशन लेना सुप्रीम कोर्ट ने समझा कि वो कॉम्पनसेशन दे ही नहीं सकते क्योंकि उनके पास रिसोर्सेज ही नहीं थे. पहली बार माननीय सर्वोच्च न्यायालय ने ये कहा कि एक यूनिफॉर्म विक्टिम कॉम्पनसेशन फंड होना चाहिए जो डेवलप करना चाहिए, जिसके अंदर सारे विक्टिम कॉम्पनसेशन अमाउंट जो है वो उनका समावेश हो अलग अलग स्कीम्स में, अलग अलग बिल्स में, और उसके अंतर्गत पेमेंट किया जाए. So in the Delhi Development Working Women's Forum, what happened was there were a group of 14 women who were raped inside the railway compartment, and there was another compartment which had armed services personnel which was near to the compartment, and therefore the accused who were committing rape were apprehended and nabbed by the armed forces personnel, and they were produced before the court. However, when the question of quantum of compensation was to be determined, the people who were the accused expressed the inability to pay because they did not have enough means to support. And therefore, the question before the court was whether compensation to the victims could be paid could be done so in the absence of any statutory scheme. And in the absence where the accused, out either by design or by default, does not have the means to pay. In such a case, what happens? The Supreme Court laid down in its principle that victim compensation is the duty of the state, because it is the responsibility of the government to ensure that there is something called rehabilitative justice. माननीय सर्वोच्च न्यायालय ने ये कहा कि कॉम्पनसेशन जो है वो देना स्टेट गवर्नमेंट, सेंट्रल गवर्नमेंट का दायित्व है. अगर अक्यूज पे नहीं कर पा रहा है कॉम्पनसेशन का अमाउंट या रिहैबिलिटेशन का अमाउंट, तो रिस्टोरेटिव जस्टिस जो है उसका एक बहुत ही बेसिक प्रिंसिपल है कि वो अमाउंट ऑफ कॉम्पनसेशन महिलाओं को दिया जाए. और इस प्रकार से माननीय सुप्रीम कोर्ट ने 1995 के जजमेंट में स्पेसिफिकली कहा सेंट्रल गवर्नमेंट को कि आप एक सेंट्रल विक्टिम कॉम्पनसेशन फंड क्रिएट करिए. और इसीलिए आपसे कहा जाता है कि एक सेंट्रल विक्टिम कॉम्पनसेशन स्कीम का क्रियान्वयन जो है वो 6 महीने के अंदर कर दिया जाए जजमेंट की तारीख से. अब 1995 में ये जजमेंट आया, बट अनफॉर्चुनेटली 2012 में जब दिल्ली गैंगरेप केस हुआ, और जिसकी वजह से मैंने एक पब्लिक इंटरेस्ट लिटिगेशन माननीय सर्वोच्च न्यायालय में दाखिल की और उसमें ये इशू उठाया, उस इशू में सबसे पहला क्वेश्चन ये था कि डिस्पाइट विक्टिम कॉम्पनसेशन फंड के आदेश जो निकले हुए थे उनका क्रियान्वयन 16-17 साल से नहीं किया गया है. और चूंकि नहीं किया गया है, इसीलिए मेरी दरख्वास्त थी माननीय सर्वोच्च न्यायालय से कि या तो उस विक्टिम कॉम्पनसेशन फंड बनाया जाए, और अगर नहीं बनाया जाता है तो धारा 357A to E CRPC की जो बनी हुई है उसके अंतर्गत मुआवजा और रिहैबिलिटेशन, वो दोनों एस्पेक्ट्स को ध्यान रखते हुए एक स्कीम बनाई जाए जिसका पालन पूरे देश में व्यापक रूप से किया जाए, जिसका अनुसरण इस प्रकार से हो कि एक यूनिफॉर्मिटी रहे. ऐसा ना हो कि एक स्टेट 2 लाख रुपए दे रही है रेप के कॉम्पनसेशन में, दूसरी स्टेट 5 लाख रुपए दे रही है, तीसरी स्टेट 1 लाख रुपए दे रही है, और कई जगहों पे ये भी देखा जा रहा था कि एक स्टेट सिर्फ 50,000 रुपए दे रही है. Right? So what happened before the Supreme Court was that despite all these provisions being there, there was no victim compensation scheme. Therefore, when the Delhi gang rape case happened in the year 2012, I filed a petition before the Honorable Supreme Court of India. I took a couple of grounds and I said that despite the judgment of the Honorable Supreme Court in the year 1995, there was no victim compensation scheme in place until that time. And therefore, a specific request was made before the Honorable Supreme Court to ensure that either you devise a scheme, second, or otherwise you ensure that the existing statute, which is the Criminal Procedure Code and specifically section 357A of CRPC, which deals with compensation, must have a uniform compensatory scheme. Now, the reason for preferring that petition before the court was that there was complete lack of uniformity of all schemes. While in a couple of cases, the compensation for rape was awarded at 100,000 rupees. At other places, it was only 50,000. At other places or in different states, it was 700,000 rupees to up to 1 million rupees. So there was a complete lack of uniformity, which propelled the Honorable Supreme Court to ensure that A, there is a scheme in place, B, it is not an ex gratia payment, that it is not in the whims and fancies or the budgetary constraints of the state government. So that tomorrow a state government or a provincial government or a regional government cannot come up and say, look here, we want to pay compensation, but we don't have the budgetary allocation to pay that compensation, right? Also, there was an inherent disparity amongst different states. States which had more revenue, which had more resources at their disposal, could disburse a greater amount of compensation, whereas states which did not have that much greater resources at their disposal could not pay as much, right? So you would see a lot of discrepancies there. Also, there were different aspects to it which were highlighted in the petition, the most important aspect was, when do you pay compensation? Number two, to who do you pay compensation? Which is to say, who is eligible for compensation? And third, what do you mean by compensation? 3 प्रकार के प्रश्न माननीय सर्वोच्च न्यायालय के सामने रखे गए थे मेरे को। पहला था कि कॉम्पनसेशन जो है वो कब उसका भुगतान किया जाए। दूसरा था कि कौन इस कॉम्पनसेशन की पात्रता रखता है, यानी कौन एलिजिबल है इस कॉम्पनसेशन के लिए। और तीसरा था कि कॉम्पनसेशन का मतलब क्या है और किस किस तरीके से कॉम्पनसेशन दिया जा सकता है। माननीय सर्वोच्च न्यायालय के समक्ष सबसे पहला जजमेंट जो था वो था 2017 और 2019 का। 2017 और 2019 के जो जजमेंट्स थे माननीय सर्वोच्च न्यायालय के, उनके साइटेशन है 2020-18 SCC पेज 499 और 2019-13 SCC पेज 715। उसमें माननीय सर्वोच्च न्यायालय ने ये कहा है कि विक्टिम कॉम्पनसेशन स्कीम जो है उसको यूनिफॉर्म होना पड़ेगा। ऐसा नहीं है कि एक स्टेट में, चूंकि एक स्टेट बहुत ज्यादा पैसा है उसके पास, इसीलिए वो ज्यादा भुगतान करेगी, और ऐसा नहीं होना चाहिए कि एक स्टेट जिसके पास कम रेवेन्यू वो कम भुगतान करे, क्योंकि इंसान की गलती नहीं है कि वो किस स्टेट में उसका रेप हुआ है। It matters therefore that there has to be a uniformity there. दूसरी चीज जो माननीय सर्वोच्च न्यायालय ने कहा था वो ये था कि एक जो भी आप स्कीम बना रहे हैं उसका जो भुगतान होने वाला है वो 2 तरीके से होगा। सबसे पहला जो भुगतान होगा वो होगा एक इंटरिम स्टेज पे, यानी इंटरिम कॉम्पनसेशन के रूप में पेबल होगा। एक बार इंटरिम कॉम्पनसेशन के रूप में भुगतान हो जाए उसके ही बाद आप फाइनल कॉम्पनसेशन डिसाइड करेंगे असेसमेंट के बाद। जो चैलेंज था माननीय सर्वोच्च न्यायालय के सामने वो ये था कि पेमेंट अगर इंटरिम कॉम्पनसेशन के रूप में किया जा रहा है तो वो कितना प्रतिशत होना चाहिए। माननीय सर्वोच्च न्यायालय ने कहा कि आप 80-20 प्रिंसिपल अपनाइए। 20% कॉम्पनसेशन इमीडिएटली इंटरिम लेवल पे देना चाहिए। उससे क्या होगा कि मेडिकल ट्रीटमेंट जो इमीडिएट होता है रेप केसेस में या सेक्सुअल असॉल्ट केसेस में, रिहैबिलिटेशन जो इमीडिएटली रिक्वायरमेंट होती है, अगर डेथ होती है तो फ्यूनरल एक्सपेंसेस उसके, और यदि किसी भी प्रकार के रेप से HIV हो रहा है या एड्स कॉन्टैक्ट हो रहा है, किसी भी प्रकार की सेक्सुअली ट्रांसमिटेड डिसीजेस हो रही हैं, तो उन केसेस में इमीडिएट पेमेंट करना चाहिए। 80% का जो अमाउंट है वो एप्लीकेशन आप मूव करेंगे नालसा या DLSA या SLSA के समक्ष, और DLSA और SLSA डिसाइड करेगी कि उस एप्लीकेशन में कितना कॉम्पनसेशन नियत करना चाहिए, और वो एप्लीकेशन आप 60 डेज में डिसाइड करेंगे। The Honorable Supreme Court said that insofar as disbursement of compensatory amount is concerned, there has to be 2 ways in which the compensation will be disbursed. First way is through interim measure, and the second, of course, is the final compensation. The ratio which has to be followed is a 20-80 ratio. 20% amount has to be disbursed during the interim stage, and 80% amount has to be disbursed at the stage of final determination. An application has to be placed before the District Legal Services Authority or the State Legal Services Authority by the victim, and the word victim would include any of her dependents also. So in case the person who is a rape survivor is not in a position to go and make that application herself, any person who is a relative, which is her next of kin, kith, friend or relative, any person can go and apply or make that application before the DLSA or the SLSA. Once an application is received, immediate interim compensation to the tune of 20% has to be disbursed, and 80% compensation has to be decided at the final stage. इस पे माननीय सुप्रीम कोर्ट ने ये भी कहा कि जब जैसे ही एप्लीकेशन मिलती है वैसे ही मैंडेटरी रिपोर्टिंग करनी पड़ेगी पुलिस को। जैसे अगर कोई रेप का इंस्टेंस सामने आया है DLSA के सामने, तो पहले DLSA को ये पूछना पड़ेगा कि क्या इसमें एक FIR पंजीबद्ध हुई है। अगर FIR रजिस्टर नहीं हुई है तो वो कॉपी ऑफ एप्लीकेशन जो भी SHO होंगे, जो भी महिला थाना के SHO होंगे, या जो भी 0 FIR के बेसिस पे हुई है, अगर महिला थाना के SHO उस वक्त ड्यूटी पे नहीं है तो उनको एक कॉपी प्रेषित की जाएगी। उनसे कहा जाएगा कि सर्वप्रथम तो आप पंजीबद्ध करिए, FIR प्राथमिकी दर्ज करिए, और जैसे ही आपने प्राथमिकी दर्ज की है उसी के साथ आप कॉम्पनसेशन अमाउंट को भी क्लियर करेंगे। वो एप्लीकेशन पे रिकमेंडेशन जैसी आएगी वैसी DLSA उसको क्लियर करेगा 20%। नाउ there may be instances of false reporting. There may be cases where the commission of offense, or let's say even after the offense has been committed, later on it is found out that the case was false. In that case, what happens? The Supreme Court said that in cases where there is a manifest false case which has been leveled, then you must take back the amount. You must recover the amount. And now there is a distinction. A false case has to be differentiated from a case where there is lack of evidence or no evidence. माननीय सर्वोच्च न्यायालय ने यह कहा है कि ऐसे प्रकरण जो झूठे प्रकरण बनाए जाते हैं उनमें रिकवरी का भी प्रावधान होना चाहिए, जिससे कॉम्पनसेशन अगर आपने डिसबर्स कर दिया है डीएलएसए ने, तो वो कॉम्पनसेशन वो वापस रिकवर कर सकते हैं और रिकवरी प्रोसीडिंग्स इनिशिएट की जा सकती हैं उनके विरुद्ध। पर माननीय सर्वोच्च न्यायालय ने यह भी उल्लेखित किया है कि एक बहुत बड़ा डिफरेंस होता है झूठे केस में और पर्याप्त साक्ष्य न होने के केस में। झूठा केस वो है जिसमें आप डेलिबरेटली झूठ बोल रहे हैं, और अपर्याप्त साक्ष्य का वो केस है जहां आप बोल तो सच रहे हैं पर आप उसको प्रूव नहीं कर पा रहे। इसीलिए सिर्फ पहले केस में, यानी फॉर्मर केस में जहां आपको पता है कि झूठ बोला जा रहा है, सिर्फ उसी केस में रिकवरी प्रोसीडिंग्स इनिशिएट की जा सकती है। जहां साक्ष्य अपर्याप्त हो या जहां आप प्रूव नहीं कर पा रहे हैं, बिकॉज हम सबको पता है कि मैक्सिमम रेप केसेस वो होते हैं, या पॉक्सो के जितने भी चाइल्ड सेक्सुअल असॉल्ट केसेस वो होते हैं, वो या तो एक लोनली एनवायरनमेंट में किए जाते हैं, अंधेरे में किए जाते हैं, डार्कनेस में किए जाते हैं, या ऐसे किए जाता है जो एक बहुत ही सिक्लूडेड एरिया हो, जहां यूजुअली आपके पास कोई विटनेस नहीं होता ये एस्टैब्लिश करने के लिए कि भाई इन इंसान के साथ इस तारीख को इस वक्त के दरमियान रेप हुआ है। इन चीजों को प्रैक्टिकली समझते हुए सुप्रीम कोर्ट ने कहा है कि जहां पे भी साक्ष्य अपर्याप्त हो या आप किसी को प्रोड्यूस नहीं कर पा रहे हैं, और जबकि आपके 164 स्टेटमेंट कंसिस्टेंट है, आपका 161 का बयान कंसिस्टेंट है, आपके जितने भी बयान है वो कंसिस्टेंट है, पर कोई और बाहरी साक्ष्य आपकी स्टोरी को सपोर्ट नहीं कर पा रहा है, और यदि इस वजह से अपर्याप्त साक्ष्यों की वजह से आपके केस को डिसमिस भी किया जाता है, तो भी जो कॉम्पनसेशन आपको दिया गया है वो वाजिब होगा और उसकी रिकवरी नहीं की जाएगी। नाउ insofar as the 80% amount is concerned, which is the final compensation, the Supreme Court has clearly said that this 80% of the amount will be deposited with a fixed deposit in the name of the victim for a minimum period of 3 years. And until a period of 3 years, the victim cannot withdraw that amount. It is only after the period of 3 years that a victim will be allowed to withdraw the amount, which many a times is very, very essential, because that amount is kept in a fixed deposit, so it earns interest. So that when the actual disbursement happens, you get more than what you were initially allocated. Of course, in case there's an emergency in the family, in case there's a household medical emergency or any other sort of emergency, then there are provisions which say that you can make an application to the District Legal Services Authority, the DLSA, or the State Legal Services Authority, the SLSA, and they will have to decide your application and allow you to withdraw your amount. Now, many a times what used to happen was that once the amount was disbursed, the husband or the relative or anybody else under whose protection that woman victim was used to misappropriate that amount. Now, in order to curb instances of misappropriation, this Honorable Supreme Court said that what you should do is you must first have the amount deposited in her account. If she has an account, a bank account, if she does not have a bank account, then the State District Legal Services Authority or the State Legal Services Authority must handhold her to enable her to open a savings bank account. And once you have opened a savings bank account, then only the deposit shall be made there. Now, what happens in case the survivor or the victim of that rape is a person of foreign origin or a foreign national who is just traveling to India and therefore she's raped? In that case, a traveler's check or an amount could be immediately given to her in cash, so that you don't have to go and have a bank account opened up or follow the regular formalities that are there, right? तो माननीय सर्वोच्च न्यायालय ने ये कहा कि अगर किसी भी प्रकार का, क्योंकि बहुत बार सुप्रीम कोर्ट ने ये भी देखा है कि काफी ऐसे केसेस थे जहां जो भी आपने मुआवजे की राशि दी वो उनके फैमिली मेंबर्स या उनके हस्बैंड्स या कई बार उनके पैटर्नल जितने भी फिगर्स होते थे वो उस पैसे को उनसे छीन लेते थे और वो उस औरत के मुआवजे के लिए यूज नहीं हो पाता था उसमें वो पैसा। इसीलिए माननीय सर्वोच्च न्यायालय ने ये कहा कि हम एक काम करेंगे, हम जो 80% की जो रकम है, जो फाइनल कॉम्पनसेशन होगा, उसको एक सेविंग्स बैंक अकाउंट में रखवाएंगे। और अगर सेविंग्स बैंक अकाउंट नहीं है किसी भी औरत का, तो डीएलएसए और एसएलएसए की ये जवाबदारी होगी, ये जिम्मेदारी होगी कि वो एक सेविंग्स बैंक अकाउंट ओपन करवाएं। और जैसे ही वो खाता चालू होगा, उसके बाद उस अकाउंट में 80% राशि रखी जाएगी। जिस दिनांक को 80% राशि रखी जाएगी, उस दिनांक से 3 साल की अवधि तक वो उस धनराशि का आहरण आप नहीं कर सकते। उस धनराशि का आहरण आप सिर्फ 3 साल के बाद करेंगे, जब तक उस पर इंटरेस्ट भी लग जाएगा। इसीलिए जो भी अमाउंट कॉम्पनसेशन का दिया था, उससे कहीं ज्यादा अमाउंट वापस लौट के आएगा। अगर वो चाइल्ड सेक्सुअल ऑफेंस का केस है, तो वो गार्जियन के साथ एक ज्वाइंट अकाउंट खोला जाएगा और ये भी माना जाएगा कि अगर गार्जियन या बच्ची या बच्चा जो भी है वो 18 साल या एज ऑफ मेजॉरिटी अटेन करते हैं, तो उस तारीख से 3 साल गिने जाएंगे। और जैसे ही वो 3 साल की समयावधि खत्म होगी, उस टाइम पे जितना भी मुआवजा दे है, उसके साथ जितना भी इंटरेस्ट कंपोनेंट उस पर जुड़ गया है, वो पूरी की पूरी समुचित धनराशि इनके ये आहरण कर पाएंगे। कई बार हाउएवर सुप्रीम कोर्ट ने यह भी कहा है कि अगर किसी प्रकार की मेडिकल इमरजेंसी है या किसी भी प्रकार की नेसेसिटी है, तो आप डीएलएसए या एसएलएसए को लिख सकते हैं, ये कहते हुए कि श्रीमान इस प्रकार की इमरजेंसी है, इसीलिए मुझे इस नकद का आहरण उसकी समयावधि खत्म होने से पहले करने की इजाजत दी जाए। और वो एप्लीकेशन जो है वो डीएलएसए या एसएलएसए को 60 दिनों के अंदर डिसाइड करनी होती है। ठीक है, तो ये जो है, ये काफी स्कीम्स थी जो यूनिफॉर्म विक्टिम कॉम्पनसेशन स्कीम जो है वो नेशनल लीगल सर्विसेज अथॉरिटी ने डिवाइस की। हम लोग सब बैठे थे जिसमें इन सारे विषयों पे चर्चा हुई थी कि झूठे प्रकरणों का क्या किया जाए, ऐसे केसेस में क्या किया जाए जहां इमीडिएटली फ्यूनरल एक्सपेंसेस की जरूरत है, मेडिकल नेसेसिटी की जरूरत है, फेशियल रिकंस्ट्रक्शन सर्जरीज की जरूरत है, किसी भी प्रकार के पेनिट्रेटिव सेक्सुअल असॉल्ट के बाद किसी भी प्रकार की इमरजेंसी सर्विसेज या सर्जरी की जरूरत है। उन सारे केसेस में क्या क्या मापदंड होंगे। तो मेरे हिसाब से माननीय सर्वोच्च न्यायालय ने इस पूरे तंत्र को स्पष्ट किया। अब बात करते हैं पॉक्सो केसेस स्पेसिफिकली की। स्कीम में एक बहुत ही इंपॉर्टेंट प्रोविजन है जो ये कहता है कि पॉक्सो केसेस में जो कॉम्पनसेशन का अमाउंट प्रिस्क्राइब्ड है वो 50% अधिक दिया जाएगा जो शेड्यूल में है। तो मैं आपके साथ वो शेड्यूल शेयर करना चाहूंगा। एक मिनट।
निपुण आप व्हाट्सएप भी कर दीजिएगा, इंपॉर्टेंट शेड्यूल है, सबको शेयर कर दूंगा मैं।
जी, आप ये शेड्यूल देख पा रहे होंगे।
जी देख पा रहे हैं, थोड़ा सा जी।
शेड्यूल एप्लीकेबल टू विमेन विक्टिम्स ऑफ क्राइम। और इस शेड्यूल में उससे पहले बहुत इंपॉर्टेंट यह है कि यदि माइनर विक्टिम होगा तो फिर उसका जो भुगतान होगा वो 50% इस शेड्यूल से ऊपर किया जाएगा। ये लिखा है, मोreover in case the victim is minor, the limit of compensation shall be deemed to be 50% higher than the amount mentioned in the schedule appended to this chapter. ये जो शेड्यूल है इसमें कम से कम 13 डिफरेंट तरीके के ऑफेंसेस हैं। पहला है यदि मृत्यु हो जाती है तो मिनिमम कॉम्पनसेशन 5 लाख है और मैक्सिमम कॉम्पनसेशन 10 लाख है। वेरोनिका, फॉर योर रेफरेंस, 10 लाख इज अबाउट 1 मिलियन रुपीज। गैंग रेप के केस में मिनिमम अमाउंट इज 5 लाख रुपीज, मैक्सिमम अमाउंट 10 लाख रुपए है। अब आप इस पे 50% अमाउंट का जो स्लैब है वो आप बढ़ा सकते हैं चाइल्ड सेक्सुअल ऑफेंसेस केसेस में। रेप में मिनिमम अमाउंट है 4 लाख रुपीज, मैक्सिमम अमाउंट है 7 लाख रुपए। अननेचुरल सेक्सुअल असॉल्ट जो सेक्शन 377 में आता है, जो सेम सेक्स सेक्सुअल असॉल्ट के केसेस होते हैं उन, या फिर ट्रांसजेंडर्स ट्रांसवर्साइड्स के साथ सेक्सुअल असॉल्ट होता है, तो उन केसेस में मिनिमम कॉम्पनसेशन 4 लाख और मैक्सिमम 7 लाख होता है। अगर लॉस ऑफ लिम्ब है, 80% डिसेबिलिटी परमानेंट आती है तो 2 लाख और 5 लाख रुपीस, और 40 से 80% होगा तो 2 लाख टू 4 लाख, और अगर 20% से 40% के बीच है डिसेबिलिटी तो 1 लाख टू 3 लाख। ऐसे ही 20% से कम है तो 1 लाख टू 2 लाख। अगर किसी भी प्रकार की ग्रीवियस फिजिकल इंजुरी है तो 1 लाख टू 2 लाख। किसी भी प्रकार के बच्चे या फीटस या मिसकैरिएज होता है ऑन अकाउंट ऑफ रेप या ऑन अकाउंट ऑफ असॉल्ट तो मिनिमम 2 लाख रुपए या मैक्सिमम 3 लाख रुपए उस फीटस का मिलेगा। और अगर प्रेगनेंसी हो जाती है रेप की वजह से तो 3 लाख रुपए मिनिमम, 4 लाख रुपए मैक्सिमम। और बर्निंग के केसेस जो हैं वो एक और माननीय सर्वोच्च न्यायालय का आदेश था जिसका नाम था रिट पिटीशन क्रिमिनल कॉल्ड लक्ष्मी वर्सेस स्टेट ऑफ वर्सेस यूनियन ऑफ इंडिया। लक्ष्मी के केस में भी माननीय सर्वोच्च न्यायालय ने यह कहा था कि इन सारे केसेस में जहां डिसफिगरमेंट हो रहा है, जहां एसिड अटैक है, वहां आप देखेंगे कि जो कॉम्पनसेशन अमाउंट का स्लैब है वो थोड़ा बड़ा हुआ है। वो इसीलिए बड़ा हुआ है क्योंकि डिसफिगरमेंट ऑफ फेस, फेशियल रिकंस्ट्रक्शन सर्जरीज, प्लास्टिक सर्जरीज, बहुत अलग अलग तरीके की सर्जरीज लगती हैं जो बहुत ही ज्यादा ग्रूसम होती हैं और जिनका खर्चा बहुत ज्यादा आता है। तो मेरे हिसाब से ये एक बहुत ही व्यापक स्कीम बनाई गई थी। अब इसमें सबसे पहला जो ऑब्जेक्शन था वो ये लिया गया था माननीय सर्वोच्च न्यायालय के समक्ष कि देखिए सेक्शन 33 पॉक्सो एक्ट में स्पेसिफिकली एक विक्टिम कॉम्पनसेशन प्रोविजन प्रोवाइडेड है जो कहता है कि स्पेशल कोर्ट जो पॉक्सो का है वो डिसाइड करेगा कि कॉम्पनसेशन क्या होना चाहिए। और अगर आप उस सेक्शन 33 को रूल 20 के साथ पढ़े, रूल 20 नए मॉडल रूल्स का, और उससे पहले जो रूल थे वो रूल 7 था, अगर उन तीनों को पढ़ें तो आपको ये समझ में आएगा कि स्पेशल कोर्ट को पावर तो दे दी है, पर किन मापदंड के बेसिस पे स्पेशल कोर्ट इस पावर को एक्सरसाइज करेगा वो नहीं दिया गया है। तो माननीय सर्वोच्च न्यायालय ने कहा 2019 के 13 एससीसी वाले जजमेंट में मेरे ही केस में कि जब तक कोई रूल्स या कोई स्कीम नहीं फॉलो होती है, ये नालसा द्वारा बनाई गई यूनिफॉर्म विक्टिम कॉम्पनसेशन स्कीम ही प्रभावी होगी पॉक्सो के केसेस को डिसाइड करने के लिए। ऐसे केसेस जहां बहुत छोटी बच्चे हैं, जहां बहुत एक्सटेंसिव सर्जरी होगी, वहां इस शेड्यूल से बढ़कर भी पैसा दिया जा सकता है। एक बहुत इंपॉर्टेंट बात है क्योंकि कई बार लोग कहते हैं कि भाई हम सिर्फ इस शेड्यूल में जितना भी मिनिमम बैंड है उसी को फॉलो करेंगे। ऐसा जरूरी नहीं है। माननीय सर्वोच्च न्यायालय ने क्लैरिफाई किया है इस जजमेंट में ये कहते हुए ये कॉमन मिनिमम है, ये बेसिक है, ये बेयर मिनिमम है। अगर इससे अधिक आपको लगता है कि आप डिसबर्स कर सकते हैं तो प्लीज करिए। मैक्सिमम यहां सिर्फ डायरेक्टरी है, मैंडेटरी नहीं है, ये ऑप्शनल है। परंतु अगर चाइल्ड का बेस्ट इंटरेस्ट रिक्वायर करता है कि इससे कहीं अधिक मुआवजे की रकम निर्धारित होनी चाहिए तो वो करेगा कोर्ट। ये बहुत इंपॉर्टेंट पॉइंट है बिकॉज मैंने काफी जगह देखा हुआ है कि स्टेट गवर्नमेंट्स, डीएलएसएस, एसएलएसएस मना कर देते हैं विक्टिम कॉम्पनसेशन देने के लिए, ये कह के कि भाई ये जो अमाउंट है बस इतना है और इससे ज्यादा हम दे नहीं सकते और चूंकि हमारा डिस्क्रिशन है इसीलिए हम दे देंगे। ऐसे भी एक सिचुएशन को हम फर्ज करते हैं कि अगर आपको मुआवजा मिला हो वो अपर्याप्त राशि है और आप उसको चैलेंज करना चाहते हैं तो धारा 372 सीआरपीसी के प्रोवाइजो में आप उस रकम के विरुद्ध एक अपील दायर कर सकते हैं, ये कहते हुए कि साहब जो हमें मिला था वो हमारे हिसाब से मेडिकल बिल्स ये कहते थे पर हमें जो अमाउंट एक्चुअली डिसबर्स किया है वो बहुत ही कम डिसबर्स किया है। ऐसी स्थिति में स्टेट लीगल सर्विसेज अथॉरिटी को पैसे आपको देने पड़ेंगे। और अच्छा, अब ये बहुत इंटरेस्टिंग मैटर है कि एक यूनिफॉर्मिटी आ गई है। पहले, इससे पहले क्या होता था कि एक एक्सग्रेशिया पेमेंट होता था। एक्सग्रेशिया पेमेंट का बेसिकली मतलब ये होता है कि गवर्नमेंट की इच्छा, इस साल सरकार बनी और इस साल सरकार को लगता है कि महिला सुरक्षा बहुत बड़ा मुद्दा है तो इस साल सरकार उसको उसके लिए एक बजट में आवंटित कर देगी पैसा। अगले साल सरकार नहीं बनी तो पैसा लैप्स हो गया और कोई पैसा नहीं बचा। माननीय सुप्रीम कोर्ट ने कहा है कि ये जो निर्भया फंड है 3500 करोड़ रुपए का, इसको एक रिकरिंग फंड बनाया जाएगा। इससे फर्क नहीं पड़ता कि सरकार किसकी भी हो, किसी भी पार्टी की सरकार हो, सेंट्रल गवर्नमेंट को ये फंड हमेशा बना के रखना पड़ेगा और इसका जो पेमेंट है वो कंसोलिडेटेड फंड ऑफ इंडिया से किया जाएगा। तो ये जो फंड है ये एक्चुअली पार्लियामेंट्री फंड है, ये किसी सरकार विशेष का फंड नहीं है। इसीलिए अगर आपको कोई भी कहता है, बिकॉज मैंने बहुत जगह ये भी सुना है कि लोग कहते हैं साहब पैसा खत्म हो गया, हम कहां से दें, आपको कोई पैसा डिनाई कर ही नहीं सकता, इसका रिकरिंग बजट आवंटित है। तीसरी समस्या जो मैं देखता हूं वो ये है कि किस प्रकार से CWCs इसमें हेल्प कर सकती हैं। CWCs किसी भी चाइल्ड सेक्सुअल ऑफेंसेस के केस में एक एप्लीकेशन बनवा सकती हैं, जो फॉर्म 1 है, जो स्कीम के साथ अपेंडेड है। वो मैं फॉर्म और स्कीम आपके साथ शेयर करूंगा। दूसरी चीज, आप फॉलो अप कर सकते हैं। कानून ये कहता है कि 60 दिन के अंदर वो स्कीम डिसाइड कर देनी चाहिए। यदि वो नहीं करती है तो CWC एक प्रोएक्टिव रोल लेकर वो एक एप्लीकेशन या अपील फाइल कर सकता है, कहते हुए कि क्यों अभी तक पैसा आवंटित नहीं हुआ है, और सॉरी, जो पैसा आवंटित था उसका डिसबर्सल क्यों नहीं हुआ है, और अगर डिसबर्सल हुआ है तो कितना हुआ है। आप हैंड होल्ड कर सकते हैं बच्चे को। अच्छा, एक और बहुत इंपॉर्टेंट चीज है कि चूंकि पॉक्सो जो है वो बच्चों के ऊपर समान रूप से अप्लाई होता है, क्योंकि वो एक जेंडर न्यूट्रल प्रावधान है। विक्टिम कॉम्पनसेशन स्कीम भी जेंडर न्यूट्रल है। माननीय सर्वोच्च न्यायालय ने यह क्लैरिफाई किया है कि इससे फर्क नहीं पड़ता कि वो एक बच्ची है या एक बच्चा है, अगर वो 18 साल की उम्र से छोटे हैं और उनके साथ किसी भी प्रकार के ऑफेंस कमिट किया गया है जो एग्रीवेटेड पेनिट्रेटिव असॉल्ट हो, सेक्शन 3 में आ रहा है, सेक्शन 5 में आ रहा है, सेक्शन 6 में आ रहा है, 7 में आ रहा है, या 9 में आ रहा है, या 11 में आ रहा है, किसी भी प्रोविजन में आ रहा हो पॉक्सो एक्ट के, उनकी पात्रता बन जाती है। और इसीलिए भले ही स्कीम में सिर्फ विमेन डिफाइंड हो, जजमेंट ऑफ सुप्रीम कोर्ट के अगर आप लाइट में या कंटेक्स्ट में उसको देखेंगे तो आपको पता पड़ेगा कि ये एक जेंडर न्यूट्रल स्कीम है, और इसीलिए इसका भुगतान जो है वो समान रूप से सबके लिए होगा। इस स्कीम के आ जाने के बाद से एक तीसरा जजमेंट है माननीय सर्वोच्च न्यायालय का, जो है आपके आइडेंटिटी प्रोटेक्शन ऑफ विमेन। आइडेंटिटी प्रोटेक्शन ऑफ विमेन जो है वो एक डायरेक्शन दिया गया है हर प्रकार की मीडिया को, प्रिंट मीडिया, इलेक्ट्रॉनिक मीडिया, सोशल मीडिया, ये कहते हुए कि अगर किसी भी प्रकार का रेप केस आपके नजर में आता है या किसी भी प्रकार के रेप केस की आपको रिपोर्टिंग करनी है, तो आपको इस हिसाब से रिपोर्टिंग करनी होगी जिसमें आप प्रोसिक्यूट्रिक्स जो है उसकी ना आप वल्दियत, ना आप उनकी आइडेंटिटी, ना आप उनका नाम, ना उनका एड्रेस, ना उनका पता, ना उनके टेलीफोन नंबर्स या कॉन्टैक्ट डिटेल्स, या वो किस गांव के हैं, या वो किस मोहल्ले में रहते हैं, या वो कहाँ काम करते हैं, या वो किस स्कूल या कॉलेज जाते हैं, इनमें से कोई भी डिटेल आप उजागर नहीं कर सकते। बिकॉज उसमें ये माना गया है कि जो भारत का जो कॉन्टेक्स्ट है उसमें आज भी रेप को एक सोशल ऑस्ट्रेसाइजेशन की तरह देखा जाता है। अगर किसी का रेप हुआ है या किसी के साथ सेक्सुअल असॉल्ट हुआ है तो ये मान लिया जाता है कि या तो उसकी भी गलती रही होगी, या अगर उसकी गलती नहीं भी होगी तो वो किसी प्रकार से एक अछूत मान ली जाती है। इन सारी जो रूढ़िवादी, जो ऑर्थोडॉक्स मेंटेलिटी है, उससे बाहर निकलते हुए माननीय सर्वोच्च न्यायालय ने 2019 2 SCC 703 जो जजमेंट है, जिसको कहते हैं निपुन सक्सेना नंबर 3 केस जो है, उसमें ये कहा गया है कि इन सारे केसेस में ये दायित्व है मीडिया का, ये दायित्व है पुलिस का, इन्वेस्टिगेटिंग एजेंसीज का, वकीलों का, कोर्ट का, इनफैक्ट सबका, कि इंश्योर करें कि नाम, आइडेंटिटी या किसी भी प्रकार से किसी भी रूप में वो उजागर ना हो या उनकी वल्दियत पता ना पड़े। अगर ऐसा किया गया तो 228A IPC में उस पार्टी के विरुद्ध दंडात्मक कार्रवाई की जाएगी। मीडिया हाउसेस के अगेंस्ट दंडात्मक कार्रवाई की जाएगी। इनफैक्ट उन वकीलों के अगेंस्ट की जाएगी या उन पुलिस ऑफिसर्स के अगेंस्ट की जाएगी जो वो किसी भी प्रकार से उसका नाम उजागर करते हैं। ना FIR में नाम होगा, ना उसके 161 के बयानों में नाम होगा, ना 164 के बयानों में नाम होगा, ना 232 के स्टेटमेंट्स में नाम होगा। 313 भी अगर अक्यूज का हो रहा होगा तो उसमें से वो नाम जो है वो रिडैक्ट कर लिया जाएगा। ये बहुत ही इंपॉर्टेंट है, बिकॉज इससे क्या हुआ कि जो विटनेसेस इन्फ्लुएंस हो रहे थे या जिनके ऊपर प्रेशर बनाया जाता था, जो दबाव बनाया जाता था, क्योंकि उनकी वल्दियत पता है, तो एक्यूज यूजुअली कांटेक्ट कर उनके घर परिवार वालों के ऊपर दबाव बनाते थे कि अपनी टेस्टिमनी या तो वापस ले लो या कॉम्प्रोमाइज कर लो या जो भी कर सकते हो वो कर लीजिए, स्टैंड मत लो हमारे अगेंस्ट, या गायब हो जाओ या उल्टा सीधा कह दो। इन सारे सिचुएशंस में भी औरत को प्रोटेक्ट किया जाता है। इसी के एक स्टेप और लिया गया है कि यदि बच्चे के लिए अगर इतना मुश्किल हो रहा है, क्योंकि कई बार चाइल्ड सेक्सुअल असॉल्ट केसेस होते हैं जो फैमिली मेंबर्स द्वारा ही किए जाते हैं या क्लोज रिलेटिव्स द्वारा किए जाते हैं, इन सारी केसेस में बोल दिया गया है कि बच्चों को एक विटनेस प्रोटेक्शन स्कीम का भी लाभ मिल सकता है। वो विटनेस प्रोटेक्शन स्कीम कैसे होगी, क्रियान्वयन उसका कैसे होगा, ये सारी जो बारीकियां हैं, ये सुप्रीम कोर्ट ने एक बहुत बड़े डायरेक्शंस इशू किए हुए हैं और ये एक ऑनगोइंग प्रक्रिया है जिसका भी मैं आपको विवरण दूंगा। तो मेरे हिसाब से ये कुछ बहुत ही कम समय में मैं ये सारे जजमेंट्स आप सबके समक्ष रख पाया। दो और आखिरी जजमेंट्स हैं जो बहुत इंपॉर्टेंट, जो मेरी समझ से मुझे प्लेस करना चाहिए। पहला है अभी बहुत रिसेंटली आया है माननीय न्यायमूर्ति सूर्यकांत जी की बेंच द्वारा, जो ये कहता है कि अगर पॉक्सो के केसेस में बच्ची ने रेप होने का खुलासा 9 साल या 10 साल बाद भी किया है, तो भी उसके बेसिस पे या उसके सेंटेंस पे एफआईआर पंजीबद्ध होगी और ट्रायल चलेगा। जस्ट बिकॉज वो एक्सप्लेन नहीं कर पा रही है डिले, ये कोई ग्राउंड नहीं है कि उसकी टेस्टिमनी, उसके 164 के बयान या उसके 161 के बयान को डिस्कार्ड कर दिया जाए यदि उसके बयान अदरवाइज डिस्क्लोज कर रहे हैं कि रेप हुआ है। दूसरी चीज जो माननीय सर्वोच्च न्यायालय ने ये स्पष्ट की है वो ये है कि प्रोसिक्यूट्रिक्स की फैमिली मेंबर्स के पास पूरा अधिकार है कि वो किसी भी स्टेज में किसी भी ऑर्डर को चैलेंज कर सके। आमतौर पर प्रावधान ये कहता है कि जब बेल की सुनवाई होती है तो अक्यूज्ड और स्टेट के बीच होती है, उसमें कंप्लेनेंट का कोई रोल नहीं होता है। पर कंप्लेनेंट का रोल रेप केसेस और सेक्सुअल असॉल्ट केसेस में सुप्रीम कोर्ट ने कहा है कि बिना कंप्लेनेंट को सुने कोई भी जज कोई ऑर्डर पास नहीं करेगा। ये केस ये मैं इसलिए बता रहा हूं क्योंकि सीडब्ल्यूसी जुडिशियल ऑर्डर्स भी देखते हैं। अगर सीडब्ल्यूसी को लगता है कि एक ऐसा जुडिशियल ऑर्डर पास हुआ है जिसमें बेल इन पे इलाज कर दिया है बिना आपके कंप्लेनेंट या प्रोसिक्यूट्रिक्स को सुने हुए या उनका पक्ष लिए हुए, तो ये बहुत ही गलत बात है। वो ऑर्डर एक्स फेसी वायलेशन ऑफ लॉ में है और उस ऑर्डर को सेटिसाइड किया जा सकता है आराम से। तो ये कुछ नए जजमेंट्स हैं, मिस एक्स वर्सेस स्टेट ऑफ झारखंड और मिस ए वर्सेस स्टेट ऑफ उत्तर प्रदेश, जिसमें माननीय सर्वोच्च न्यायालय ने ये डायरेक्शंस दिए गए हैं। तो इसी के साथ मैं अपने इस डिस्कोर्स पे विराम लगाऊंगा। थैंक यू सो मच एवरीबॉडी, आप लोगों ने बहुत पेशेंटली सुना।
It's always been a great pleasure to listen you, और काफी बिजी रहते हैं उसके बाद भी आपने समय दिया। Veronica, there is a question for you. The questions are coming. We will take another 10 minutes, not more than that. Veronica, I have a question for you. Sapna ji has from Delhi has asked one question. How many children are there in foster care in Tanzania? The number of foster care children in Tanzania. Veronica.
That's a hard question to respond, because now currently in Tanzania, in the first place, we don't have proper foster care operating. And then we have one challenge of statistics. So I might not be in a position to give you reliable statistics on as far as foster care is concerned in Tanzania, because we are lacking such statistics at the moment.
Yes, Vasundhara ji, you want to say something?
Yes, I also have one question for Veronica and one for Nipun ji. Veronica, first to you. I just want to know, because you said that fostering to adoption is very common in Tanzania. And just when you foster a child for 6 months, the family can go for adoption and they can really adopt the child. Don't you think that 6 months is very less time from going from fostering to adoption? Because in India also we have that, but then we have 5 years. You have to foster a child for 5 years, then only you can go for adoption. So what is that experience and what the practice is, how it is, like is it going very well that okay they are going for fostering for 5-6 months and then they can adoption, that how it is working as of now, Veronica, for you. एंड निपुण जी आपसे मेरा क्वेश्चन तो ये है कि बहुत कुछ जो है सुप्रीम कोर्ट से बहुत सारी गाइडलाइंस आती है, लेकिन जब हम CWC मेंबर काम करते थे हमारे पास ये जानकारी नहीं होती थी, नंबर 1। दूसरा ये कि जो विक्टिम है और विक्टिम की फैमिली है उनको भी इसके बारे में कोई जानकारी नहीं है, तो उस जानकारी को जो बेनिफिशियरी है वहां तक पहुंचाने के लिए क्या स्टेप्स लिए जा रहे हैं, दैट इज वेरी इंपॉर्टेंट बिकॉज नोबडी नोज। मैं आज आपसे सुन रही हूँ, मुझे लग रहा है ओहो ये भी है, अच्छा ये भी है, अच्छा ये भी है, लेकिन जिन लोगों को नहीं मालूम वो फिर उस वहां तक पहुंच ही नहीं पाते हैं। सो अब क्या किया है इसके लिए, मतलब कुछ स्टेप्स लिए हैं, नालसा स्टेप ले रही है, डालसा स्टेप ले रही है, तो वी शुड नो हाउ वी कैन गेट इन्वॉल्व एंड टेक द बेनिफिट ऑफ दिस ऑल दिस कंपनसेशन व्हिच इज रियली needed by the victim's family and by the victim. So first, Veronica, maybe you can answer that.
Thank you, Pastor, for your question. Maybe let me correct myself. When I say common, it's not like it takes like fostering for adoption takes place so often. So actually what I mean is like it's at least the practice of foster care that we have is associated to adoption. Like so far, that's how it's taking place. Now about the 6 months period, whether that is not too short, in the first place, I'm not even sure like why the law puts this 6 months, and you'll be surprised, like for foreigners to adopt in Tanzania, they only need to foster for 3 months for foreigners. Yes.
Oh, okay.
But now in practice, as you said, it's a bit different in practice because sometimes, maybe because of the way the social welfare office operates, there have been complaints recently that sometimes children overstay in foster care. Like, because as I said, foster care is only done when somebody comes to express an interest to adopt, but then the law requires that before you adopt, you have to foster a child for 6 months. So in most cases, supervision visits are not done during this fosterage period. And if the parent or if the person who is fostering is not going back to remind the authorities to go for supervision, this child would continue being in foster care. So usually how fast the adoption takes place, it would be at the initiative of the person who wants to adopt the child. Because usually if you don't make follow-up with the authorities, sometimes there's a tendency to forget about children who have been placed in foster care for purposes of adoption.
And another question is, sorry to interrupt, like you said that only wealthy families, they become foster parents. So like, how? Like only because you don't give money, so you are expecting wealthy families to come forward and take children into foster care? It's like what?
That is a presumption. Like that's my own analysis. That if I look at the society, the Tanzanian society, the way it is now, and the way the child protection system operates, it would only be for, maybe not for the wealth, but for the middle class at least. And maybe even those the middle class who don't have children, because for instance in Tanzania, public education is not so good, so parents have to go for private schools to take their children to school. So if you have maybe 4 children of your own, you would think twice of adding up another child if there is no any support that is given to facilitate the care for this child. So that was only my own analysis or presumption of analysis of the current situation as it is.
Yeah. Thank you, Veronica. And I think there are many things which are common and slightly different. So I think we need more discussion.
A lot many questions are coming. So I request everybody to please be specific. Over to you, Nipun. Nipun, आप muted हैं. Please unmute your mic. Yeah.
Right. So the response to Vasundhara ma'am's question is this. Yes, in terms of the Supreme Court's judgment, wide publicity was ordered to be given to the scheme. This scheme was made operational from 2nd October, Gandhi Jayanti 2018. So this scheme has been in force for the last 4 years. And there have been many souls that have been, compensated on account of the scheme being in place. It is widely circulated on NALSA. All you have to do is type victim compensation scheme NALSA और आपके पास आ जाएगा.